Okay, well, it's 2 o'clock here on Eastern time, so I'm going to go ahead and get started. Good afternoon, everyone. My name's Ellie Garrity. I'm the manager of alumni career programs with the Alumni Association. We're so excited that you're able to join us for today's TERP Talk, Legal Pitfalls to Avoid When Building a $1 Million Brand. This webinar is part of the Alumni Association's professional development webinar series, in which we hope to provide thought-provoking and valuable content that help alumni like you achieve your personal and professional goals. We have a lot of information to cover today, but we want you to get the most out of this webinar. So just make sure we all stay on mute. And there we go, perfect. Make sure we try to stay on mute so we can hear Chayla when she's presenting. And then if you do have any questions, feel free to drop those in the chat throughout the presentation. I will be happy to let Chayla know we have some questions coming in. Now, a little bit about our presenter, Chayla Jackson. She's an attorney, entrepreneur, and author of Build a Legit Business. Chayla graduated from Georgetown Law, where she trained as a litigator in criminal defense and in clinical teaching before pivoting to teach entrepreneurs how to protect their brand, build a legacy, and secure their wealth. She trains and equips entrepreneurs on how to legally protect their businesses and profits with confidence and avoid costly legal mistakes. Chayla is also the CEO of Legacy Legal Consulting, a firm providing legal consulting services to women CEOs and small business owners. Chayla is a Maryland alumna, graduating in 2010 with her bachelor's in African American Studies. And I'll hand it over to you, Chayla, to kick things off.
All right. Hello. Welcome, everyone. And thank you, Ellie, for that wonderful introduction. As folks are coming in, please share what state you are tuning in from. I would love to hear where you guys are from, especially since a lot of us are all Zoomed out. For those who are tuning in, please remember to put your mic on mute. So, all right. As you can see, this is legal pitfalls to avoid when building a $1 million brand. So I want to welcome you to this workshop. Ellie did a wonderful job introducing me, so I am not going to spend a lot of time introducing myself. So what she did not share is I am the founder of Build a Legit Biz, which is a brand that teaches legal education to CEOs to help them build and protect their brand with confidence. So a part of that is during COVID-19, a lot of us had an amazing surprise and shock, right? When the world kind of shut down with the pandemic. And so for a lot of entrepreneurs, it was an opportunity to pivot in their business. And that is exactly what I did. I wrote a book after finding out that so many entrepreneurs were making costly legal mistakes that could easily be avoided. And so this workshop comes out of that book because it allowed for me to get invited here to talk to you today. So we are going to jump in and get started. One of the things is I like to be interactive. So please make sure that you are ready to type in the chat box. We have a couple of polls. I want to hear from you. I want to engage with you. If you have questions, make sure that in the chat box, you put #Q and your question. That way we don't lose it in the chat box as people are coming in. So hello, Joe from Nevada, Beverly from DC, welcome Lowell from Maryland, and there was someone else as the chat is coming in that I may have missed, but I saw Georgia. So welcome. It's amazing to have you guys here from all of these different states. If I'm talking too fast as we go through this workshop, please let me know and I will try my best to slow down. Hi, Alan from Florida, welcome. Let's get started a little bit. We have two polls. Ellie, could we bring the first poll up? And I am going to turn off my video and I will bring it up periodically as you guys have questions so you can see me. All right. So the first question, if you can just answer this, guys, is how long have you been in business? I want to know a little bit about that because that's going to help us, or at least help me as we go through this workshop to see where you guys are. So we have, 3 people who, oh, it's increasing. Okay. So a couple of folks who've been in business for 0 to 2 years. All right, a couple for 2 to 5 and someone for 15 plus years. Congratulations for the 15 plus years. You're hanging in there. Congratulations. All right, let's move on to the second poll. All right, so we are bringing up the second poll now. So if you guys can answer this question, and it is, what are the sources you've used to learn about the laws of doing business?
And Chayla, I gave folks the option to pick multiple options. So
Yeah,
you may see a couple reoccurring answers here as folks might be able to pick a couple of these options.
perfect. All right, so perfect. So some of you have read books, Google, which is a very common one. Some of you have spoken with an attorney, which is awesome, and taken a legal course. Amazing, amazing, amazing. So that kind of gives me, this is great. It gives me some understanding of where you guys may be and how to kind of maybe give you a little bit more during today's presentation. So let us get started. So what do you guys notice or recognize about these brands? Give me 1 second, trying to move the chat box. So some of these, right, some of these brands, they are well known, they're famous, you've seen them before, Coca-Cola, Pepsi, Nike, Apple. One of the things that we're talking about when we talk about building a $1 million brand is understanding what a brand is. Because when you see these images, you recognize it automatically. And so for some of you, you may not be at the $1 million mark yet, but all of these brands started somewhere. They started at a beginning stage, or what sometimes I refer to as a seed, right? They started somewhere and they built their businesses. Some of these are not $1 million brands, but $1 billion brands, but they started taking one step at a time to build their business. And so there is a difference between a business and a brand. And so we want to discuss that very quickly. A business is the mechanism for how you transact and operate your business. So one of the things that I like to explain when I teach is that as soon as you begin to exchange a product or service, you are in business. You are operating a business. But a brand is something different. A brand is like the emotional image appeal or the message that represents your business, your product, or your service. It can also be you. You could be your brand. The thing about brands is that their brands can be the colors you use, the words, the pictures, the packaging, the stories that you tell that represent and communicate the mood or or communicate the message you want to communicate to your ideal client and or customer. So understanding that the business is the backbone for the brand, but the brand attracts who you are targeting. So the business is what will continue, the business will determine if they keep coming back for more. Your brand is what will help them get in the door. But these pieces are a part of building your $1 million brand, because you need the brand, but you also need the business. So question for you, what is in your brand bank? And what I mean by that is that your brand is an asset, right? All of this is a part of an asset of building the asset of your business, building your financials with your business. So what is in your brand bank? What is it that you currently have that represents your brand? Do you have photos? Do you have a logo that's well known? Do you have a website, a signature product line course? What do you currently have that is in your brand bank? And you can drop that in the comment, in the chat box. What's in your brand bank? So we have logos, taglines, emotional push, reputation. Reputation is big, right? A part of your brand. Are you consistent? Awesome, right? This is important, right? What is in your brand bank? Because all of this is a part of building your $1 million brand. So why do we care, right? Why do we even care? Why are we here? You can't even begin to build with materials of your brand if you don't own it. And you can't build a $1 million brand if the money coming in is exiting your bank account to deal with lawsuits, lawyers, and fixing what could have been avoided if you had done it the legit way the first time around. So that's why we're here, right? We want to avoid legal pitfalls that can basically be a hole in our money bag as we build our $1 million brand. So what are these pitfalls? So let's start with pitfall number 1. Financial mismanagement. So this guy, I don't know if you guys have ever had a Famous Amos cookie, if you have ever heard of Wally Amos, but Wally Amos is the founder of Famous Amos Cookies. He started the company back in 1975, just with startup capital, right? He reached out to celebrities that we might know of, Marvin Gaye, Helen Reddy, and a few others, to gather up $25,000 of startup capital, right? So this would be initial investment capital. And he invested in the company and he quickly sold about $300,000 in cookies, right? That's a lot of cookies, but he quickly saw the growth of his company. In 1982, the revenue of his company, after he had moved into franchising, even having a store in Bloomingdale's and in other locations, it grew to $12 million. But here's the thing. Around 1985, because of his financial mismanagement, he was forced to start selling parts of his company off. And as he began selling parts of his company off, he eventually sold off more equity than he owned. And so in your business, right, when you own your business, you have equity. You have equity in your business. And the more equity you have, the more control over the company you have. Well, he began selling off parts of his company and began losing control of the company, then having to sell it, and he lost his company. So he sold it, and the company was sold a couple of times. But when he did sell it, he sold it for $61 million in 1992. $61 million. So had he been more financially responsible, He could have been, instead of selling it for, a lesser amount, he could have had more in his pocket. The other thing is that when he lost his company, he tried to start another company. But because of a contract he sold, he was legally barred from using his own name and his likeness on any further food products. So not only did he lose the company, which was very successful and is still, selling famous Amos cookies today, but he also lost the right for a period of time to use his own likeness, his own image, right? His image became the brand on another food product when he tried to launch a new business. So this is a pitfall that you want to be careful of not knowing the financials of your business. What is your cash flow? What is your revenue? What is your profit and loss statement, and understanding where the money is coming. Another example of financial mismanagement is Alexa Katz. So she is an attorney. She grew her law firm to be $1 million law firm and began teaching other attorneys how to do so as well. And she quickly grew her business to be $1 million law firm, but her downfall was that as the money was coming in, she wasn't putting enough money to the side to pay the taxes. And so, as any entrepreneur starting, you get excited when the revenue is coming in, but not necessarily realizing that the more money you make, the tax bill can go up as well. And so she ended up owing taxes. Then her debt and her business increased. There was a lawsuit that took place that eventually added more on top of that. And she ended up having to file for bankruptcy. So what turned into $1 million brand, she ended up losing it because of her financial mismanagement or not understanding how to manage the money in her business when it comes to taxes. So how do you avoid this pitfall? One, hire a qualified and a good CPA. The second is you want to learn yourself, right? You want to know what the numbers are in your business so that if your CPA makes a mistake, you're aware that this is something that could possibly be an issue, but you can also begin to take steps to rectify it, because at the end of the day, you're going to be on the hook. The next thing is you want to make sure that you pay your taxes and you pay your taxes on time. Again, set aside money as you earn for, set aside money that you're earning for taxes. Keep accurate records, because you also want to be able to write off eligible deductions, because you can legally pay less taxes. And that is also important when you're building $1 million brand. And then you want, again, legally limit your tax liability. So that's what I was talking about. Legally limit your tax liability. So pitfall number 2 that you want to avoid when building $1 million brand. This one is a big one, and it's losing ownership of your intellectual property. So I don't know if of you guys have heard of intellectual property before, but I'm going to briefly explain it. So my definition of intellectual property is that intellectual property is the real estate of your mind. It is the real estate of your creative genius as expressed outside of your mind. And so there are 4 categories of intellectual property. You have trademarks, copyrights, trade patents, and trade secrets. Trademarks are your logos, your slogans, the name of your business, the things that you put on products or services that identify your business or your brand in the marketplace. So it helps distinguish you. So some examples of that is the Google G, Google, and just do it. It could also be the Nike swoosh sign, or Nike when you see the word, as well as the Apple logo. All of those are examples of trademarks. Copyrights they're the right that attaches to works that you create. So creative works of original authorship. So that includes books, music, plays. It can include your blog posts, copy, right? Written works that's on your website. It can also include manuscripts if you're writing something for a TV production or a movie. So anything that deals with creative works of authorship, even audio and courses, will fall under copyrights. Next, you have patents, which deals with inventions, and then trade secrets, which deals with those proprietary secrets that are essential to the trade of your business and making money. And the key to this is that it must be kept confidential. There are additional steps taken for that information to be kept confidential. An example of that would be the recipe for Coca-Cola or the Hershey chocolate kisses. So that's a breakdown of intellectual property. And again, as we go through this, and if you have any questions whatsoever, just put hashtag Q in your question. Do not be afraid of asking any question whatsoever. Just drop it in there because I want to make sure that you walk away with understanding. So, losing ownership. An example that came out, a couple of months ago was Nick Cannon. Nick Cannon he was with Viacom hosting Wild 'N Out, which started in 2005. As an employee of the company, he had, Nick Cannon has his own brand. He has multiple things that he does through music and other things as well. But there was an incident that took place where he spoke out. And because of him speaking out in that matter, Viacom decided to fire him. Now, here's the thing. Nick Cannon is the creative genius behind Wild 'N Out, which brings on several celebrities. They do skits, comedy, everything you can imagine. Think of that is creative, fun, and funky for a particular audience. While he was the creative genius, he walked away not owning anything to it. And so he had grown Wild 'N Out to be $1 million brand, yet he doesn't own it. So even though it was created and started in 2005, there wasn't a trademark filed until 2019 and 2020. And Viacom is the one that actually filed it, which is, a little crazy if you think about it, right? Someone creates it, had years to be able to secure ownership, but decided not to. So Viacom filed multiple trademarks for Wild 'N Out to use it in different ways, in different avenues. And as you can see, it started in 2005, but the filing date was not until March 1st, 2019. And so one of the things about the trademark process that you guys should be aware of when building your $1 million brand is that even in the process, there is an opportunity where you can challenge somebody securing ownership to their trademark. And this is important because recently there was a company that tried to secure their trademark, and Apple, which is well known, they have a robust legal department, they have the money to go to court, decided to try to stop them from getting their trademark. Now, here's the thing. If you're just starting out, you may not have the financial capital to be able to go up against a company like Apple to secure the trademark to your brand, right? Because what a trademark does is it gives you exclusive rights to use that mark, that slogan, that logo, that tagline, that name in that particular category or industry of business, whether it's food, apparel, or music, whatever category it is. And there are about 45 different categories that you can select with the US Patent and Trademark Office. So he had time, didn't do it, right? And so they filed for different marks. This one was a service mark to use it in media. This one, however, was to be used for clothes, but he did not do that. Here's another example of someone who they avoided the legal pitfall. And so Michaela is someone who, she is an actress, but she's also very creative works. She wrote the script for this show, and it was starting to get picked up. And so one of the things that she was doing is she was shopping it around, and she shopped it to Netflix. Now, Netflix was offering her $1 million for this so they can show it on their platforms. However, Netflix wanted full ownership of the entire thing. And so she was negotiating with them to have a percentage of the ownership, because with ownership comes royalties. So royalties is something is that as they were getting paid, if whatever percentage she had of that, she would have continued to get paid a percentage of that as well. So Netflix was negotiating, she was negotiating for 5%, and someone had told her that that wasn't possible. So she went as low as 0.5% of a copyright, and they literally would not budge from getting full ownership. And so she walked away from $1 million deal to then go with BBC. This is a powerful example that as you are building your $1 million brand, whether you are in entertainment or not, that there is bargaining power to you owning what you create and what represents your brand, so that if you do need to sell your company or you do decide to open up a franchise, you can either transfer the right to your trademarks or copyrights, or you can license them out so that people can pay you to use what you've created and what you spent time building. The other thing that you want to consider is that trademarks and copyrights can continue after you leave this earth, which means that your children and your children's children can continue to profit off of the work that you do today, of what you build. But if you don't own it, you can't pass that wealth on. Another example in terms of losing copyright ownership, because sometimes thinking about celebrities, we oftentimes don't think that it can happen to us. There was a CEO of one who had a podcast, and because she was a CEO of one looking to expand her business as she grows and expands, she decided to seek out a publisher to publish her podcast. So put it together and publish it onto different platforms. But in that process, she didn't realize that she had literally signed away a license, an exclusive license to her podcast, meaning that the publisher was going to be able to profit and use her podcast just because she signed it away. And that in order for her to get her rights back, she would have had to fit certain provisions in the contract, but also have to pay him. And so we reviewed this contract and, was able to show her there was an intellectual property clause. And so that is something that you want to look for if you are using any kind of publisher or any kind of hosting site, because even some hosting sites and platforms can have a term in their terms and conditions or in their contracts that will have you transfer your rights to your trademarks, to your copyrights over to them, or give them a license to use. And if you do that, understand that when you do not have or do not own the right to your creative works, to the logo, the slogan that represents your brand in the marketplace, you cannot monetize that. And if you cannot monetize that, it is no longer an asset to your business. And so you want to make sure that you check the clauses so you don't relinquish your rights, and read and understand every contract in terms of use so you don't make those same mistakes or that pitfall. So avoiding this, you want to make sure that you do one or all of these options. Hire an attorney to represent you or negotiate you in your contracts, especially if you're doing an intellectual property licensing deal. That's not something that you want to do yourself. Next, you want to, if you can, negotiate yourself, because there are some areas where you are adequately prepared to be the negotiator. But if you're not, get an attorney. Next, you want to ensure your intellectual property rights are secured in the contract. Before you engage and work with anyone, before you, hire someone or go into business with someone, you want to make sure that the intellectual property rights of anything created within that business relationship, anything that you had before, is secure so that you own it and you do not lose that right. Fourth, read the fine print of everything. Always read. And a cheat sheet, or a cheat tip, I should say, an easy route to do this is to control find for intellectual property or copyrights and trademarks, and look for whatever that is highlighted so that you can, skim to those terms and read that more in detail and take your time. Next, you want to file to own your trademarks and copyrights. Trademarks are filed with the U.S. Patent and Trademark Office, and copyrights are filed with the U.S. Copyright Office. And then last but not least, you want to follow the legal guidelines to maintain your ownership once you file. So with the U.S. Patent and Trademark Office, after about 5 to 6 years, you have to file again to say that you are still using that trademark in business. But once you do that, you're good. But you have to continue to use it in business, or else you can lose the trademark. With the U.S. Copyright Office, once you create your work, it is usually good for the lifetime of the author plus 70 years after that. All right. So, question for you, because this is about your $1 million brand. What parts of your brand and or your products or services are for you are, oh, sorry, Ellie, I saw the poll pop up. So it kind of took me off guard. So question for you guys.
Sorry.
That's all right. That's all right. It happens. Question for you guys. What part of your brand and products or services are key for you to own to build $1 million brand? Right? So what are you currently using in your business to represent your brand? What products, services that you have that is key for you to own, to secure that ownership as you build your $1 million brand? So you can just include that in the chat box. And for those who joined in a little bit late, just to let you know, I am interactive. So don't feel afraid to, this is not like a Zoom where you sit back and you don't participate, but participate so you can get the most out of this. But also I want to hear about your businesses. So Stuart, I see your client list. Client list especially is something that could fall under trade secrets. If you take precautions to keep it confidential, definitely something that, that literally a Rolodex, what they used to call it back in the day, but your client list is definitely something that is important for your brand. Another example could be your email list. COVID-19 didn't start everyone, going virtual, but a lot of people built virtual businesses. And with that, email lists are so important to the building of your brand, your business, right? Alan, we have trademarks and trade secrets as we cannot patent. Tell me a little bit more about that, Alan. What do you mean by that? So when I say what parts, go ahead.
I just unmuted. We've done a lot of reviews of the constituents and components of our product, and it's probably could be easily argued that anybody familiar in the art could come up with these conclusions. There are nothing in the production processes that are particularly difficult. So speed to market, trademarks, and any trade secrets in product constituents and production we have is what's going to be critical for us. Because most of the legal opinion, my own opinion is there's nothing here that's unique to somebody experienced in the art.
Well, is there a business name? Is there a logo? There's
There's
something?
all of that. Yeah, we have the name, logos. The name is going to end up being probably the most critical for us,
Okay.
and that's where we may have a bit of an argument with the USPTO.
Mhm.
But we think we'll get around that. That's going to be critical, as well as the branding. There are unique aspects of it that some of our brand equity is going to be in timing to market as well.
Perfect, right? So
may not be trade markable, right? There are still other elements that are essential to owning or protecting. Are there any others that you guys have?
Looks like
Any
Lowell
others
put in the
according to-
chat IP.
So that's intellectual property.
That's correct.
So tell me a little bit more. What part of intellectual property? Like what part
It's
your
it's a mechanical device. So
Okay.
the inner workings of the device and the operations of the device. But mainly
So
the
you may be looking
electronics.
more at patents.
I'm sorry.
So you may be looking more at patents
Well, I've
for your
already filed it
invention?
and gotten it. Yes.
Okay.
Mhm.
Okay. Awesome. Awesome. Another thing to consider, Lowell, am I saying it correctly?
That's right.
Okay. Is, even with intellectual property, and this goes for everyone, while some of your products or some of your inventions may fall under one category, it can also fall under another. So the name for your device, how you brand it, could fall under trademarks. If you have any written materials, manuals, instructions, that can fall under copyright.
Okay.
So there are multiple components to how you can protect and own each part of your intellectual property. Thank you,
Okay.
Lowell.
Thank you.
Thank you, everyone. All right, so let's move on to pitfall number 3. So pitfall number 3. Okay, I'm hearing a little echo. Okay, perfect. So pitfall number 3, using what you don't own. So some of you may know these people and some of you may not. This is not a question that I'm expecting for you to answer, but it's, what does, besides being a celebrity, does J-Lo, LeBron James, Kim Kardashian, and the others have in common? And the answer to that is copyright infringement. So for some of you, you may be using social media to promote your business or going through other routes to market. If you are using a website, if you are using marketing materials, if you are using social media or anywhere where where photos or you're using any type of copyright, you want to make sure that you own it. And so these individuals, what they ended up doing was they ended up taking a photo that someone else had taken of them and putting it on their social media accounts. And the photographers who took the photo sued them in court for doing so. Why? Because technically they own the photo. And when you own something, you have the right to determine how and if it can be used by someone else. And if it can be used, what the amount would be. So remember, this is the intellectual property: trademarks, copyrights, patents, and trade secrets. So there's one thing to use something and there's another thing to own it. So with copyrights, the original creator is the copyright owner. So if you create it, you own it. But with trademarks, just because you use it doesn't mean you own it. So just because you have a business name, a brand name, just because you have a logo or a slogan or tagline, it does not mean that you own it. Ownership is contingent upon a couple of factors. First, are you using it in business when it comes to trademarks? Is whatever you're using affixed to a product or service that is actually being used? The second is jurisdiction. Where exactly are you using it? Is your business only operating within a particular state in the US? Is your business operating in multiple states, or is it overseas, right? So it's limited. But when we talk about trademarks, we're talking about the US, because international trademarks have to go through the international trademark system, or whatever country's trademark system there is. Next is category. There are 45 different categories. So if you're using a trademark for, in the avenue of, let's say apparel. Apparel is one category, but that same trademark could be used by someone else and say, let's say legal services. Why? Because the two categories are different. And trademarks are all about there not being any confusion in the marketplace. So if it's going to bring confusion, oftentimes it's going to be an issue. But if there is no confusion, two people can be using the same exact name in two different categories, as long as there's not going to be confusion in the marketplace with the consumer. The next thing, and this is the most important, is the first in use. So oftentimes when there is a challenge with trademarks about can someone register this trademark, or who's the actual owner, it is always going to come down to who was the first to use it in commerce. The first to use is so important. And remember that with trademarks, the point of registering is to have exclusive rights, and it's usually given to original filers, as long as you pass through that process. So here's a question for you. And this is, Ellie, if you can pull up the next poll. Do you own it? You hire a videographer to record content for a new course or your website that you're launching. Do you own it? Yes or no? You hire a photographer to record content for you. Do you own it? Yes or no? So I have a few people saying yes and a few people saying no. Okay. Someone tell me why. Someone who said yes, tell me why you said yes.
Because you paid the videographer for his services. So you paid him to produce the product.
Okay. Okay. So because you paid. All right.
Right.
All right. Someone who said no, tell me why.
Because unless you sign a contract, technically the photographer owns it.
Okay. All right. So in this scenario, the answer is no. You do not own it. And the reason given is exactly what was said. Unless there is a contract in place, the original owner owns it. Now, here's the thing. Alan, you are correct. If you have a contract in place, it depends on the terms of that contract. I promised I was going to take my video off so you guys could see me, and sometimes I get excited and I forget. But sometimes there's a contract in place, and if you have a contract in place, it depends on the terms of the contract. So standard rule applies. When someone creates something for you, whether it's a video, whether it's content for your website, whether it's they take photos for you, they own it. The only time that you own something that someone creates for you is if they transfer the exclusive right to it to you. So there has to be a provision in the contract, and it has to be an exclusive right. And you want to make sure that it's for commercial purposes and non-commercial purposes, because if it's not for a commercial purpose, you're going to be limited. You're not going to be able to use that in your business. So So the answer is no. That's the first answer. However, if there's a contract, the answer could be yes, with that provision in place. All right, let's bring up the next poll. So for the past 5 years, and just wait 1 second, Ellie, for the past 5 years, you have been using your signature logo on your products, your websites, your marketing materials, and social media posts. Your brand logo is now in 10 states in America, but you've never officially filed the trademark registration for it. Now we can bring up the poll. Do you own it? So we have no coming in. All right. Someone who said yes, tell me why. And if you don't want to mute and say why, it's okay. All right. Someone who said no, tell me why. And it can be anyone.
Again, if you don't follow the proper paperwork, depending on your state, you don't own it.
So here's where it can get a little bit dicey, right, when it comes to the law, right, in terms of ownership. Technically, when you create something, you can own it. You can own it. However, to have exclusive rights to use it, to own it, to block people from using it, which really comes with, right, the ability to own something, right? When you own a house, you can prevent someone from coming in your house. You can kick trespassers off. You can get people arrested if necessary because you own the house. However, with your trademarks, you can own something, you can own it in terms of, you're using it, but in order to exclude people, yes, you need to file for registration. That's the best route to do that. I want to mention there is state registration and federal registration. State registration limits you to the state, but federal registration will give you access to secure it throughout the United States. All right. So let's go on. So how do you avoid this pitfall? So one, if you're using images, because this is not something that happens to just celebrities, there are also other CEOs who have gotten started, used images that they found on Google or elsewhere thinking that it was okay. And the original photographer found the image. They wasn't using it for sale, it was just on their website. But because they did not have the right to use it, they ended up receiving a cease and desist letter telling them they had 30 days to take it down, and they had to pay $5,000 or risk being taken to court and paying more than that, $10,000. So this is not something that's just limited to just your social media, but even if it's on your website, it is something that can literally cost you money. So you want to make sure that you're using license-free or royalty-free images. It can also be for music, videos, or GIFs. Some places you can get those from, and you can also Google or seek others, is Pitfalls, Pixabay, and Canva. One caveat, not caveat, but one thing I do want to mention is even if you are hiring someone else to build your website or to do any type of marketing for you, you want to make sure that what they are using, they have a license to use, they own, that ownership is transferred to you. because just because you hired someone else to do it for you does not exclude you from being responsible for it. So you want to make sure that you cover all of your bases. The next is, again, we talked about this, is contractually transferring the exclusive copyright or trademark ownership to you from the original owner. So if you don't own it, you can have it transferred in a copyright. You can have it transferred in a contract. The other thing that you can do is you could buy the license, AKA the right to use, whether it's an exclusive license or a non-exclusive license, you can do that. And then you can read the fine print. Always read the fine print to make sure that you understand what it is that you're getting, how you can use it, and whether or not you own it. So, pitfall number 4 is skipping the tax bill. So COVID-19 has really changed the how businesses are doing economically, but it's also impacted the revenue that states are taking in from sales tax and business revenue, things that otherwise they would have been doing. I can't recall the state right now, but there was one state that literally lost millions of dollars in just sales tax revenue because of the mandatory shutdowns. And whenever that happens, you can automatically know that there is going to be more of an increased awareness or investigation and a lookout in terms of what businesses are actually making money and not paying sales tax and what's going on, because states are looking to generate revenue and looking for their money. And so there have been an increase of a number of arrests regards sales tax evasion. And this is not something to take lightly, because it can be a federal crime. Criminal charges are being made and arrests are being made in a number of states. So sales tax is one of those things that you really want to pay attention to. And so even if you are selling a digital product, some states require you to collect tax. Some states, like the state of Maryland, you do not have to collect tax on digital products. However, you want to make sure that you're collecting the correct amount of sales tax and that you're paying it to the correct sales tax agency, whether it's at the state level and including the local level as well, if they include an additional tax. The next thing is business taxes. Taxes in general is something that you want to pay attention to, and make sure that you're paying it to the correct authority and collecting or keeping aside the correct amount. There are legal ways you can pay less taxes. I highly suggest sitting down with a CPA to discuss that, so that you're not trying to do it yourself, because the tax law has changed, and there are ways to shift your wealth. So you just want to pay attention. What taxes do you have to pay? Making sure that you pay them. And then there's one tax that I did not include, which is a property tax. And in some states, your brand is a part of your business. Businesses are an asset. A business is seen as a separate entity from you. So if you have an LLC, a S Corp, a C Corp, or a partnership, and it's officially registered with the state, you may be required to pay a property tax. In the state of Maryland, that's $300 a year. Somewhere else, it may be a different amount. So you want to make sure that you're also paying that tax, because if you are not paying that tax, it can come back around to bite you, because they can assess a penalty on top of that. The other thing when it comes to taxes is, if, say for instance, that you don't properly shut your business down, right? You move on, you don't file the official paperwork. In California, that penalty can be increased, right? So it's already a high enough amount of fee to shut the business down in California. But if you have additional taxes, they can charge a hefty penalty on top of that. So I saw a question in the chat box. Feel free to include your question. Just type in the chat box As you guys have questions, just use hashtag Q. Okay, someone has their mic on.
Looks like we had a question that was coming through from Zay. Apologies, Zay, if I'm mispronouncing your name, but if you just want to go ahead, Zay.
Hi, yes. You said in the state of Maryland that you don't have to pay taxes on digital products. Do you mean literal, for clarity, is it literally a digital product or products that you sell digitally?
So it is a digital product. So if you have products that you're selling online, that is, if it's a physical product, like a tangible product, like, forgive me, I had to take a sip of water. You know, a physical product you can touch, even if you're selling it online, you have to pay taxes on that. Now, if you are selling, say for instance, you know, this course, this workshop right here is packaged, put online to sell. It's a digital course, a digital product. In the state of Maryland, there is no sales tax as is written in the law that's attached to digital products. They have not gotten hip to that just yet of how the law is written.
Okay, thank you.
No problem. All right, so let's keep this moving. So how do you avoid this pitfall? So one, of course, you want to collect the appropriate sales tax for physical and digital products. Use a verified accounting software and or hire a CPA bookkeeper. Keep good records and maintain those records. I recommend for up to 10 years, just because you don't know if there's ever going to be an audit. So you want to make sure that you have those records for as long as possible. Regularly set aside and pay taxes at the local, state, and federal level. And then, of course, maintain your tax accounts. Some counties and some states, and as well as the federal government, they allow for you to set up a tax account in which you can pay into that account the taxes that are required for you on whether it's a quarterly basis, a bi-monthly basis, or a yearly basis, depending on your business revenue, as well as filing the necessary tax reports or assessments. Pitfall number 5 is MIA contracts. This is a big one when you talk about building $1 million brand. So Amazon, we know Amazon. A couple of months ago, it came out that Amazon was meeting with startups about investing in their potential products. Some of them were just trying to, you know, get started, get launched. They were excited, and they were meeting with someone who could help them be an investor or get their products off the ground. Amazon then turned around after they met with these individuals and launched what they, you know, what the CEOs claim to be competing products. So instead of investing with these companies, they ended up being a competitor. This is something where if you are looking to seek investors, if you are looking to share your ideas about your, you know, we heard about some patentable inventions, whatever you are about to share about your business, you want to make sure that you have the contracts in place to protect yourself. Now, in the realm of intellectual property, ideas, just an idea, is not protected. The idea itself is not protected. It has to be the idea expressed in some tangible form. But when you have that tangible form and you're going to meet with investors, before you share your business idea, you want to make sure you have what is called a non-disclosure confidentiality agreement in place. A non-disclosure confidentiality agreement in place, right? So some of you have probably heard of NDAs, and some of you have probably heard of confidentiality agreements. I have put those two together. The reason being is that an NDA, a non-disclosure agreement, basically says that when you come to the other person to share the information, that they have a duty not to disclose it. So they just don't have to share what you shared with them. However, if you were to put a confidentiality clause in that, or to have a non-disclosure confidentiality agreement, what that would do is not just put a responsibility on them not to disclose the information that you're about to share with them for the purposes of a potential business and business relationship, but it would also make them responsible to take additional steps, be proactive to make sure the information doesn't get out. So there's a difference between I just don't have to share it, and then I have a responsibility to make sure the information doesn't leak. So that's why you want to make sure you have both. And another thing that could have been a potential here is putting in a non-compete clause to make sure that the person that you are thinking about going into business does not become your direct competitor. So this is important with building $1 million brand, because as you're developing your brand and your business, there are going to be more things that you add to your business as you're building it. But you want to make sure that someone doesn't come in and scoop up the potential profits and beat you to the market because either they have more revenue or more people power behind them than you do as you're building. Another example of a CEO that I recently had the opportunity to speak with, she's building her $1 million brand, right? Has a team in place, has gotten to 6 figures. And one of the things that took place was she had contracted with a client to do some work for her. The client signed the contract, the work had been completed, but when it came time to collect payment, the client disputed the charge with the credit card company and won, and ended up costing the CEO $5,000 in revenue and profit, right? So she did the work, but she didn't get paid for it. And so one of the things that you want to do is just because you have a contract in place, you want to make sure that no important clause or provision of that contract is missing. So your contracts need to be ironclad to make sure that when you do work for someone or whatever you're doing within your business, depending on how your business model is set up, that there is no wiggle room for them to get out of paying you, because the payment is necessary for you to build your $1 million brand. And so there are many other things that can take place, but you want to make sure that your contracts have those provisions. And you're also, right, we're talking about in terms of contracts and contract provisions, COVID-19 is happening, right? It has changed how we do business. It has changed a lot in our world. And so you want to make sure that you're looking at your contracts, if you have them, for what needs to be updated to make sure you have some room with COVID-19 going on to make changes if you need to how you perform service or how you provide the product or how you deliver, if you're, depending on what your business model is, how you're, what you're selling or what you're providing, to ensure that you are not in breach of contract if for whatever reason you need to take time off or you need to take care of a loved one or something happens with the US postal system. Or, if anything happens, you want to make sure that your contracts have wiggle room for you as well without you being in breach. And then that would cost you money. So how do you avoid this? Well, one, when it comes to looking for investors and partners, you want to make sure you do a thorough investigation. Have they been shading in business or do they have integrity? Next, you want to make sure you have the right contracts in place and read and understand them. So for the sake of time, I can't go through all of the different contracts that you can have, but you want to just make sure that you have whatever contract you need in place, whether it's a service agreement, a non-disclosure agreement, or an intellectual property agreement, whatever it is, you want to make sure that it's in place. Ensure that you have ironclad contract provisions. One of the things I see missing from certain contracts are termination clauses as well as a jurisdiction clause. You want to make sure that there are parameters for how to terminate the contract included, The other thing that you want to do is you want to make sure that if litigation needs to arise, that it happens in a court system, or it happens in a place that is conducive for your business or for you. And so this takes a little bit more research to find out, is there a court system that, if this issue comes up, it's going to turn in your favor? Or if you are doing business with people who are all over the United States, perhaps you want to make sure that any litigation takes place around this contract where you live, so that you're not commuting to, if you live in California, you're not commuting to Florida, or if you live in California, you're not commuting to New York, in order to deal with a breach of contract or any negotiation around your contract issues. Next, COVID-19 clauses. If you have physical products, right, taking advantage to include some changes to your shipping policies, cancellation, termination policies, whatever policies or clauses that you have in your contract, making sure that they are COVID-19 friendly or emergency friendly, right? Life is still going on. We don't know what's going to happen. So you want to make sure that there is something in there that gives you room, that if something happens, you're still covered. Again, we talked about non-disclosure or confidential non-disclosure agreements, non-compete clauses. The other thing is you want to file federal trademarks, copyrights, and patents. So before you meet with an investor, or before you meet with a potential business partner, having those intellectual property things secured. And so with patents, you can register a patent, and even during that process, as it's going through that process of getting patent approval, you can sell or transfer the right to that license even as it's going through the process. So that's something to be aware of. And last but not least, you want to have an experienced attorney draft your contracts or use one of their contract templates. Contracts and intellectual property are two areas where I do not ever advise you trying to do it yourself. So, question for you. What contracts do you currently have in place? What contracts do you need to put in place? And then are there any contracts that you need to update to make them relevant, whether it's COVID-19 or something else? So this is a question that you can ask, you can take with you, ask yourself. If you've been taking notes and writing this down, this is something that you can take notes for yourself to do. For the sake of time, because I want to make sure we have time for questions, because we're nearing the end of time, I'm going to finish up with our last thing. So our last one is pitfall number 6. And it's literally not investing in legal education or attorney. So most of you on here probably are, savvy enough to understand the importance of speaking with an attorney, getting the education. A lot of you took the poll earlier and said you've either read a book or you've spoken with an attorney. And so for a lot of folks, this takes a mindset shift to really think about the investment versus the cost, and think about preventing versus rehabilitating. And so for some of you, even though the cost of investing with an attorney could be in the hundreds to the thousands, it may be beneficial for you to invest now versus waiting until something happens and then having to pay not just the attorney fees, but litigation costs and any fees if you lose the litigation for the other side as well, and possibly losing your business. So it's weighing the risk and weighing the rewards as well, because an attorney can be a huge investment and save you money, because they can spot issues and potentially save you from legal pitfalls that you might not have been aware of in your particular industry. And if you're choosing to go with an attorney or looking for an attorney, you want to make sure that that attorney is barred. They are licensed to practice in that state. And you also want to make sure that they are savvy and experienced in your particular industry. Not all attorneys are made equal, and not all attorneys are made for each industry. So if you are in whatever industry, and you just want to make sure that attorney understands or works with clients who are familiar with that, who have been in that industry, so that they can properly help you navigate the legal pitfalls and save you huge, huge savings. And the reason why I say is make sure they are licensed to practice is because there is a woman who has built a $1 million marketing brand. And recently there was a person who held themselves out to be an attorney and was working with her. And she almost continued on with that attorney until she secured the proper legal representation, who then had to issue a statement about what took place. Because if you go with the wrong person or a fraud, it can do more damage, not just to your profits, but also to your brand and your business. So here is another question for you, right? Because this is a workshop. I want to make sure that you guys are getting what you need. What areas in your business would investing in a legal education or speaking with an attorney benefit you now and in the long run? So you can write 3 priority areas of where do you need to invest now as you build your $1 million brand. What are those priority areas for you? So since we are nearing our end of time, I'm going to ask you, type in the chat box. What is one takeaway from today's workshop that you will, something that you didn't know, or something that was like, okay, I needed this information. Thank you. What is one takeaway that you got that you plan to incorporate in your business moving forward to protect your brand? So you can just include that in the chat box. What is one takeaway, one aha moment? What is something that you did not know before, or something that got expanded upon that you plan to utilize and incorporate to protect your brand moving forward? So we have 1, ensure you own the rights to all your intellectual property, even if you've been using it for years. Exactly. Protect it from your business partnerships. Exactly. You want to make sure that you are protecting that. We also have trademarks. It can be something simple. Type one takeaway that you've taken from today's workshop. The other thing that I want to mention, since we're on, protecting, since Alan mentioned protecting your intellectual property rights, is you want to make sure if you have employees, if you are bringing on employees, which oftentimes takes place when you're building a $1 million brand, having in your employment contracts that anything that they create for your business, you own, and that your intellectual property cannot be used or licensed for them outside of the context of employment and within the scope of employment. Another one we have is get everything in writing. Yes, and yes. That is a huge one. Always get it in writing. For those of you who will be negotiating deals, that is a huge thing. If you have a conversation outside of the final signing of the contract, you want to make sure that everything you discussed is in that contract, because once that contract is signed, if something you discussed is not in that contract, it's outside of the purview. The courts might look at it, but oftentimes they are only looking at what's within the four corners of that document. All right. Well, are there any questions before we close out for today?
Feel free to type your questions into the chat box. And Chayla, just a quick one for you while we're waiting for them to come through. I know you gave us 6 different pitfalls. Do you have one that you think is the most important, or if there was one that people would hold on to, or maybe that would be their main takeaway from this session? Could you pinpoint one, or is that maybe too hard? Too hard?
No, of
of a
course
question?
it's not too hard of a question. I think if anything, the biggest one would be the one on losing your intellectual property rights, right? So securing your intellectual property rights, that's a major one that people overlook, because in business you can get so preoccupied with creating, with marketing, with making deals, reaching out to potential buyers, or partners, that you forget in the process to make sure that you own what it is that you're creating, or that you're not giving away the rights to it. And so oftentimes when I am teaching, it is not just about you building $1 million brand or profits now, but it's about how are you leaving a legacy and wealth for generations who will come after you. And oftentimes that is contingent upon you owning the rights to what you are building. And so that is one of the biggest legal pitfalls that I would say, if you don't leave with anything else, make sure you own it, that it is legally yours, and that no one can come in later on and say, actually, I own this, I own it, and you don't. Because if that's the case, what's going to end up happening is you're going to owe them money. You don't want to, you don't want to have to come out your pockets when the whole point is for you to grow your wealth. So it doesn't look like we have any questions, unless people are waiting for the mics to open up.
Looks like you got one shout out about how informative it was. So shout out to you. But of course, if there are any other questions, now would be the time. And Chayla, if there's anything else that you wanted to mention before we wrap up?
It really depends. Everyone is in a different industry. And so, today's presentation was kind of broad and more general. So depending on the questions that come forth, then I can give a little bit more detailed in terms of, how to guide folks in terms of avoiding legal pitfalls. But this is pretty much, I want to keep it contained, because there's so much when it comes to the laws of doing business.
Well, I don't want to cut anyone off, but it doesn't look like we have any more questions coming through. Chayla, did you want to share what you've been working on and maybe some next steps about how folks can reach you?
Sure. So first, let me thank you, Ellie, for inviting me for today, as well as the University of Maryland Alumni Association. Thank you. I'm always going to say, go Terps. Whoop, whoop. And I want to thank everyone who, took the time out to be here. Even though this was free, it is not free when it comes to your time, and your time was an investment. So I do honor you for coming and for staying for the duration of the workshop. These are some ways that you can stay in touch with me. My website is Jackson.com. If you are on Facebook or Instagram, you can also stay in touch using those social media handles, or searching Build a Legit Biz on Facebook. Some things that I have coming up, although I am kind of slowing down for quarter four the rest of this year. But what I do have available is on-demand legal education for CEOs. So if you are someone who, you want to learn a little bit more, you want to make sure that what you are doing, your business is legally legit, and you want to have confidence, then you can go to my website, IamChaylaJackson.com, and learn a little bit more about how you can get access to legal education that is on demand, and you can learn at your own pace. You can also grab my book, Build a Legit Business, that covers the laws of A to Z for how to do business. And that includes from the startup, but also exit planning, because a lot of people don't think about exit planning or succession, and particularly when it comes to estate law. So if something happens to you right now in your business, do you have a plan? Is it something written down in your contracts, or in your, not in your contracts, but your operating agreement or your bylaws? Or in your will for what happens to your business if something happens to you, because your business is an asset, and an asset can be passed on to your heirs or to someone else. So that's a little bit about what I have. I also do provide legal consultation services. Right now there is a wait list, but you can get on that wait list if that is something that interests you at IamChaylaJackson.com. So that's a little bit, Ellie, that I have going on right now.
Great. Well, thank you so much. I definitely recommend that you check out Chayla's website and check out her book. The Alumni Association even did a feature on her book on our alumni blog. So feel free to check that out. I will send along the recording of this PowerPoint and this slide so you can have access to reaching Chayla on her website and on her social media handles if you'd like. But that is all we have for you today. A huge, huge thank you to our speaker, Chayla. Thank you all again for your time. And like Chayla said, go Terps. Hope you all have a great rest of your day and talk to you all soon.
Excellent. And where can we get your book, please, Attorney Chayla?
You can get the book. You can get the book at my website, IamChaylaJackson.com,
Okay.
or you can go to buildalegitbiz.com.
Okay, great, great. You're amazing. You are amazing. So excellent. Thank you very much.
Thank you. And thank you, everyone. Thank you, Alan. Thank you, Joe. Thank you, everyone, even those who I didn't get to hear from, but I hope you have a wonderful, wonderful day. And I hope you all avoid the legal pitfalls as you build your $1 million brand.
Amazing. Thanks, Chayla. Have a great day, everyone.